Good morning. This is Hillary Sklar. I'm an attorney at Disability Rights California in the Los Angeles Regional Office. We are a statewide nonprofit that provides advocacy to Californians with disabilities, and we receive federal funding under the PAT grant, Protection and Advocacy for Assistive Technology, to provide that advocacy to individuals with disabilities and to provide assistance to advocates as well. At the end of my contact information is on the front page of this webinar. At the very end, I've included a resource page which includes the website for Disability Rights California and some other organizations that might be useful. And it is from our website that you can get the contact information for the regional office in your catchment. We have offices in Sacramento, Fresno, Oakland, Los Angeles, and San Diego. And between the 5 of our offices, we cover all the counties in the state. We also, I wanted to note, have an assistive technology manual on our website as well under the publications link. And we have a chapter about private health insurance. And we have about 17 chapters. There's also one on Medi-Cal, one on Medicare. It's a comprehensive manual that might be useful to you. This morning, I'm going to talk about assistive technology needs for people who are insured through a private health plan and only a private health plan. This is a very comprehensive topic, and so the approach that I have selected is to provide you with an overview, and my goal is to provide you with information that will give you a big picture about private health insurance plans, how they differ and may be similar than Medi-Cal. The major concepts for you to know that will help you begin to navigate or continue to navigate the system of private health insurance, and resources for information about the law and other advocacy organizations that might be useful to you. So let's begin. I have in the webinar, I have included about 3 different places to stop to ask questions after very specific topic sections, and so I'll use those times to address any questions you may have. So the first slide is our overview. As I mentioned, I'll talk about general concepts, an analysis for is there coverage under the plan, laws that apply to assistive technology. I'll talk about appeals, and then, as I mentioned earlier, resources. The first main point I want to make about private insurance appeals is that each plan could be different. And so I am going to speak in generalities intentionally because many questions will rely solely on the coverage in the health plan and any exclusions or limitations. So let's begin with general concepts. First, it's important to know that private health insurance plans are not required by law to cover assistive technology. It's purely discretionary. And the insurance companies have discretion not only about whether they will fund assistive technology, but also how they do so. And they are free to design limits, including cost limits, and limits on the types of items that they are willing to cover. And that changes from health insurance company to health insurance company, and may even change within the same health insurance company from plan to plan. In the private insurance world, assistive technology is most commonly referred to as durable medical equipment. So I just wanted to flag that when you are looking at the language of a client's plan. Next, this is probably known, but private plans are designated as either a health maintenance organization, an HMO, or a PPO, When we talk about HMOs, we are in the world of managed care, which will become important later when we need to figure out what laws may apply. Very generally, oversight is provided for HMOs through the California Department of Managed Care, and for PPOs through the California Department of Insurance. There is a caveat to that, in that there are some plans that have PPOs that actually are enforced and oversight is provided through the Department of Managed Care. So just one example about how you can have a general rule, but there may quickly be an exception to it. But when we speak about HMOs, we will always be in the land of California Department of Managed Care. So I thought it could be useful to provide an analysis of where to begin. When someone comes to you and says, I have private health insurance and I have a need for assistive technology, or I have private health insurance and I've been denied, or they're not acting in the way that they should. Where to begin? The first question, which I will not spend a lot of time on, but just wanted to flag for you, is this person who needs the AT covered by this insurance policy? That might seem sort of obvious, but here I mean more spouses, domestic partners, children. We want to make sure that this person is actually covered by this policy. Once that is addressed and answered, and if the answer is yes, then the next two questions are, is this particular piece of equipment, an AT generally, covered by this policy? And secondly, is the assistive technology sought medically necessary? And that should be familiar for anyone who's sat in on previous webinars. If the answer is yes to all three of these questions, then one should expect that the policy would pay for the AT device. But again, that's the general rule, and there could be exceptions. The plan itself is subject to any amendments that could include policy limits, co-payments that the insured is responsible to provide before coverage kicks in, or any deductibles that need to be satisfied. So is the AT device item covered by the policy? For the advocate and for our clients, the first task is to gather all the documents that comprise the health plan policy itself. What we're looking for is a clause that addresses durable medical equipment, or should they use the language of assistive technology. This includes gathering the plan itself, which usually is called the evidence of coverage, any amendments, any policy writers, and we're looking for exclusions. So there may be a clause that says this particular plan does provide for durable medical equipment. However, here are the limits. So as I mentioned earlier, private insurance companies have the discretion to do this. So we were looking for items that they do not cover. And I've listed some examples that you may see. And there may be others depending on the plan. So that may be an exclusion for no air conditioners. The plan would not cover prosthetic devices or hearing aids or computer-assisted communication devices or orthotics or eyeglasses or any equipment that's characterized as experimental. Again, I don't know that the plan will do this, but I just wanted to flag for you. We're looking for the big picture, all the documents, and then the specific language read together of all of the documents combined for what is covered and what is not covered in this particular insurance policy. A few words about funding limits. As many of you probably know, durable medical equipment, when it is covered by private health insurance plans, is typically capped at usually a low amount. And I see that I've actually made an error. My example under capitation is supposed to be $1,500. I created an amount that doesn't actually exist. So when one looks at the entire policy, we want to see if there is a capitated amount, if there is a ceiling, if their coverage on durable medical equipment has a limit for that year or for the life of this policy. And so while the policy may cover something that our clients need, it may not be feasible because of the low limit of coverage. So in addition to any capitation or limits on dollar amounts, we also want to see if the client, as the policy beneficiary, is required to provide for any co-payments. And a standard example is commonly 20% of durable medical equipment that is covered by a policy, that the beneficiary would be responsible for 20% of it. We also want to take into consideration whether our client is covered by both a private health insurance plan and Medi-Cal, for example, or Medicare and a private health insurance plan, in which case the issue that's raised is the interactions between those two different types of coverage and when Medi-Cal or Medicare may be responsible to pay for part of that DME. So the example that I provide is where a client is both a beneficiary of Medi-Cal and a private health plan. It may be that Medi-Cal would be required to provide the co-payment that the beneficiary would otherwise be responsible for. It's just an example. Again, the catch with private health plans is each plan can differ. Another word about capitation. There have been attempts over the last few years by state senators in California to address both the discretionary element around DME and these capitated rates. And we have been very active as an organization in getting legislation passed that would require coverage of DME by private health insurance plans, specifically managed care plans, and also would raise the ceiling on limits. And those bills have not passed the California legislature. But just a site of to flag for you as advocates and ILCs that should another bill come to fruition, that there's a role for all of us to play in trying to get it passed. And I say that not knowing if CFILC was very active in the Chesbro and Kuhl bill, so I apologize for that. Next, I wanted to talk about what is DME. As an attorney, I'm always interested in what words mean, because words do not always mean what we think they mean, and words can have different definitions depending on context and the particular law or policy. So here in private health insurance plans, DME will be defined depending on the policy. Common language that we have seen and to look for is that DME is able to withstand use by more than one person. DME is something that is primarily and customarily used to serve a medical purpose. And DME is not useful in the absence of illness or injury. Again, this is common language, but it may not be precisely the same in the plan that you are reviewing. As always with language and definitions, something can go wrong at any part of this definition when a client requests durable medical equipment. And so while on its surface it may just be obvious and logical that this client needs this piece of equipment, it is durable medical equipment, they need it for a medical reason, it is absolutely medically necessary, and is still denied for lack of medical necessity, for example. And I will spend a little bit of time shortly talking specifically about medical necessity. But as always, we always want to know what the language is that needs to be addressed when the person reviewing at the insurance plan reviews the request. So they will hold up the request to the definition set forth by their insurance company, whether it is durable medical equipment or not. And one site that could be contentious is able to withstand use by more than one person, because, for example, with wheelchairs, it is often the case that people need customized wheelchairs. They need seating systems that fit their body and features of the wheelchair that they specifically need for their disability. And so that could be a site of some disagreement, and one would make the argument about how customization is needed. But these are parts that are, for example, used by other people. Okay, next slide. If the answer is yes, that DME is covered by this particular policy, then the last question we need to ask is this piece of equipment medically necessary? And similar to the definition of durable medical equipment, we need to know how medical necessity is defined in the particular plan that our clients are covered by. Medical necessity may not mean the same thing in this plan that it does for Medi-Cal or Medicare, or from one plan to another plan. So the starting premise is that private insurance policies like Medi-Cal will only pay for assistive technology, or DME, that is medically necessary. As I mentioned, medical necessity, the definition is a moving target. It can change from plan to plan. But if we were to extract commonality, we often see language of the following three factors. That medical necessity means that there is consistency with symptoms or a diagnosis, treatment of a condition, disease, ailment, or injury. That it is in accordance with standards of good medical practice, and that this equipment is not merely for the convenience of the insured. For those of you who work with Medi-Cal or Medi-Cal and assistive technology, you will note that this common language is different than the medical necessity, for example, for adults who reside in the community. But similarly, the focus is going to be around a disability or medical condition. How is medical necessity determined? So we know that with Medi-Cal, for example, the practice has been that requests for assistive technology have been historically reviewed by nurses who are on staff at the Medi-Cal field office. Here, with insurance companies, it could be a doctor, it could be a nurse, or it could be someone who does not have either type of training and is a utilization agent of the insurance company. But nonetheless, the person who reviews the request will be an employee of some type of that insurance company. Again, the process for determining medical necessity could vary from plan to plan and insurance company to insurance company, but the concept of pre-authorization will likely apply, and that the process will probably be similar to the one used for Medi-Cal, which is the treatment authorization request. And the basics of pre-authorization are that a doctor certifies a need, a person has been evaluated to need this particular equipment, and then there's a discussion about medical necessity, and that this process must be done and reviewed and approved before the insurance company will fund the piece of equipment. So as always, and if anyone on the webinar has attended previous webinars, medical necessity is the key to getting approvals for our clients. And the process for pre-approval in the medical plan, or insurance plan, may not set forth in great detail the advocacy steps to address medical necessity, but similar to Medi-Cal, there's a lot of work that should go in to getting an effective recommendation, an effective written document from a doctor or health professional. And this is a site for advocacy on all of our parts, either in the pre-approval process or also where the insurance company may delay a decision or deny a request. So the first piece is to get a letter, to get a written document. The health insurance plan may provide a form, and if a form is required, that should be completed fully. But if the form, as is often the case, does not provide enough space to fully address the details and the needs of the client, then one should feel free to provide a supplemental letter on the person's letterhead that sets forth their credentials. And that could be my doctor, or, and often is the case, a physical therapist who is certified and has extensive training in evaluating and conducting assistive technology assessments. It may be a speech therapist. It depends on what the equipment is. But when getting an opinion from an expert such as one of those folks, it is very important to determine is that person in a really good position to speak to the equipment and to the client. For example, if the person has spinal cord injury or multiple sclerosis and needs a wheelchair that is customized, then we're looking for someone who has experience with one of those disabilities. It also is helpful to establish that this expert is knowledgeable about the client. Now, it may not be practical for the expert to spend vast amount of time with our client, or they may have just met our clients, but they need to know enough about the client to speak more than just adequately about this person's needs and the equipment that they are recommending. And I also want to note that it's very important that whatever is submitted in writing, whether it is the form and or a supplemental letter, that everything in it is accurate. And that may seem logical, but I know that experts are often pressed for time. And they do know our clients very well, and they do know the equipment, and they are very credible. But there are typos that are made, or our client, who is a woman, may be referred to as he when that is not the case here. Or there may be an error in the disability in one part of the letter that doesn't exist anywhere else. So it's very, very important that these written documents are complete and fully accurate. The letters will be used to prescribe and to certify that the assistive technology, or DME, that is requested will prevent disease or disability or other type of health condition, or that will prolong life. And here again, I want you to double check the language of that particular insurance policy for the definition of medical necessity. But generally, we're looking for that this piece of equipment will aid our clients in one of these ways. So in this way, there are some similarities to Medi-Cal. Again, I'm saying that here that the letter will be used to prescribe and certify. The insurance company may also require certification and a prescription via another form or an actual piece of paper from a prescription pad. Again, it is fundamental to know the requirements of that particular health policy. And the key to this letter is that it demonstrates that the equipment, the assistive technology, or DME, meets the plan's definition of medical necessity. So, components of effective letters. I've already mentioned that the letter should have the author's name, their contact information, their credentials, and the relevant expertise that they have to address and assess this particular client and their AT needs. It can be a paragraph. My name is Hillary Sklar. I have a doctorate in physical therapy. I have been employed at Rancho Los Amigos National Rehabilitation Center for 10 years. In my capacity at Rancho Los Amigos, I work with people with a range of complex disabilities. I assess their needs for seating systems and wheelchairs, etc., etc. And if applicable, I have worked with client X for the last 5 years, if that's the case. The letter should also include the client's disability or diagnosis, how long they have had this disability or diagnosis, if it is one that is lifelong or will likely continue for the rest of their lives or is more short-term, the mechanics of the disability. What is the functional or psychological impact of this disability as it is relevant to the need for assistive technology? It doesn't have to say everything about the client if it's not relevant, but here the connector is always going to be information that supports the request and need for this particular equipment. Are there any, additionally, are there any anticipated health problems or other limitations that may occur with this client if this AT is not funded or because it has not been funded? For example, the request process has gone on for months or years. And one example would be one that I see often with our Medi-Cal patients, with our Medi-Cal clients, I apologize. And that is where they need a customized, I'll use wheelchair example again, and because where their current wheelchair may have broken down or is worn out or no longer suits their needs, perhaps they've lost a significant amount of weight or gained weight and they don't fit into the wheelchair anymore, or there's a piece of the seating system that causes rubbing, or they're not able to tilt in the chair or relieve pressure in any way from their limbs. And where that has happened and where they have requested a wheelchair, and we'll use Medi-Cal as an example, but I think this would be the case with insurance companies as well, where there have been denials or delays in action to approve or deny or otherwise ask for additional information because that person no longer fits in that chair, and because that person cannot adequately relieve pressure, they now have a pressure sore. And they have a pressure sore that started out as you know, not such a big deal, but now has progressed to stage 3, stage 4. They may be in the hospital, they may have been in and out of hospitals, and all of this could have been avoided, says the doctor, if they had had the equipment that they needed all along. So just an example to illustrate an example of where our client may have been harmed or where they now have an additional disability or health condition because they have needed this equipment and had not received it. To continue about medical necessity letters, the letter should also always include a very detailed rationale for why this particular piece of equipment has been requested. Now, it may be a standard piece of equipment that is not customized in any way, or it may be a piece of equipment that every part needs to be customized for the client. And this may seem silly, and it is labor intensive, and often doctors and physical therapists and speech therapists don't have the time to do this, so it may be a bit of a negotiation, but is absolutely critical that they speak to this particular piece of equipment, no matter how obvious and logical it seems otherwise, that of course this person needs this equipment and no other piece of equipment is suitable. They still need to articulate it. And I also would have them speak to cost effectiveness in case that's an issue with the insurance company. So one piece of the discussion of rationale is, how did this expert reach the decision that this particular piece of equipment is the one? Why is it brand X and not brand Y? Why might brand X cost a little bit more than brand Y, but it must be brand X and not brand Y? Has the client tested out this equipment? Do they know that in fact this is the right equipment for them because the client has practiced on it or tried it or had a trial period with it, so that so the insurance company knows if they spend this amount of money, it is the right one. They will not be asked to buy another one because a mistake was made, etc., etc. And how will this assistive technology, or DME, be used? Will it be used at home only? Will it be used for activities of daily living? Will it be used to go to medical appointments? Will it be used at school, etc.? And then the second point I make, which I've already covered, is, was other assistive technology or DME considered and or tried by the client? And why did that not work? Or, and I've seen this with Medi-Cal, where the insurance company says, okay, we're not saying no to funding, but we are saying we think there's a different brand that will meet the medical needs of the person, and that other brand happens to cost us less. So in that situation, two things could happen. One is you go back to the client and the expert and you say, okay, the insurance company is saying they're open-minded about funding, but they think it's this other piece of equipment. You know, client, have you tried this equipment? Expert, what is your opinion on this equipment? And it may be that they just know that that piece of equipment will not do it, or it may be that the client has already tried it out and it doesn't work. Or it may be that, you know what, okay, they're right. You know, I had ruled it out because I didn't think it would work, or it was a close call when the client trialed the equipment. But yeah, it actually could work. So it could go in one of these directions. And the last point I want to make about medical necessity is whether the person reviewing it is a doctor or a nurse or a utilization review agent, it should never be assumed that that person or the team of people that they work with know anything about this client's disability or the equipment or the functional impact of the disability on this person. And I do not mean that to suggest that staff at private insurance plans don't know what they're doing, or are not educated, or don't know about disabilities. But the same disability can differ from person to person, for example. And it may be a new brand of assistive technology or a new version of that piece of equipment that's been in existence for years, everybody knows it, but now there's a new one on the block, and that's what's being requested. So again, I find that experts sometimes don't have as much patience for this piece because they are in it all day. This is their world. This is their language. But they are speaking to someone who may not speak the same language. And so it is very important to speak the language of the reviewer and to be explanatory. Okay, that ends our first segment, and I'll take questions on the topics covered. And I see a few have come in. Let me have a moment here to review. The first question is from Bruce at UCP San Diego. I'm familiar with AAC funded as medical necessity. Are you aware of instances where other APs such as computer access hardware and software was funded as medical necessity? I am not. I'm not familiar with that, and that does not mean that it has not been funded. I just am not familiar with it. I think my recommendation there would be if you, well, the first piece of the analysis is it's always going to be dependent on that particular health plan. And the health plan could change from year to year and be the same, pretty much the same health plan, or it could stay the same. So one question is to talk to others who have worked with the same insurance company or may have the same plan, or other advocates at UCP, for example, if you've not done so already. You may have done all of this already. Another very good source, an excellent source, which I include in the resource section at the end, is an organization in New York called Neighborhood Legal Services, which should not be confused with Neighborhood Legal Services of Los Angeles County. It's an entirely different organization. But why I mention them is they have a National Assistive Technology Project, and they keep tabs on insurance plans and Medi-Cal and Medicare and funding through Department of Rehabilitation and any funding source you can think of. And so if the question is generally, is this type of equipment covered, one could ask them, but also I think it really, again, begins with the first question. An analytical question is, what does this plan cover? And from year to year, the same insurance company could change the terms. I hope that is helpful. And I've provided the website for Neighborhood Legal Services at the end of the webinar. The second question is from Debbie. Have you had any luck getting regional centers to cover above the cap of the DME or the copay for the DME for those clients who have no Medi-Cal? Very good question. And again, I have to answer that I have not had the opportunity to find out if regional center would cover such. And I would defer to my colleagues at Disability Rights California who specialize in regional center advocacy. And so what I would do is, if there's a particular case that you have, I would contact the client rights advocate for that regional center that is an employee of Disability Rights California, and how you would identify who that person is, and I can help you offline with that as well if this is a particular case. But for everyone else on the call, we have a branch of Disability Rights California called Office of Clients' Rights Advocacy. Some of you may be very familiar with this. And we have advocates and attorneys, 2 per regional center, that are dedicated to advocacy for regional center consumers for a particular regional center. And that's where this would have come up more likely. So I can assist you with locating who that person is offline, or you can go to our website at the end, which is at the end of the webinar, www.disabilityrightsca.org, and we have a tab on our main page for who we are, and that includes Office of Client Rights Advocacy, and it's listed, I believe, in alphabetical order by regional center. So I hope that's helpful. But that's a question that I would defer to regional center specialists. Okay, any other Any other questions on this first part of the webinar? Okay, let's move on to the second section. Applicable law. Okay, so similar to the moving target of the plan, some of our analysis is set in stone of which law applies, and some is a little bit more of a moving target. I see another question came in. Give me 1 second here. Okay, David has said if denial is made by Medi-Cal, then yes, regional center will pay. Thank you, David. Okay, applicable law. First task is to determine which law applies, and this is going to depend on whether the health plan is an HMO or a PPO. And then there are sub-questions depending on if it's HMO or PPO. So again, as a reminder, HMO means we are in the land of managed health care, and we're under the auspices of the California Department of Managed Health Care. So we'll start with HMOs. If the client is insured by a policy that's an HMO, then we want to ask a little bit more about our client and this particular plan. Who is paying for this plan? And what type of plan is it? Is it an individual plan? Is it a group plan, meaning that it's been funded by an employer? And then the analysis follows. So if it is an individual plan, then we're looking to a variety of state laws. The KnoxKeen Act, we're looking at the California Civil Code, we're looking at the California Insurance Code, and we're looking at HIPAA laws. If it's employer-based HMO and the employer has paid for the policy, we're looking at state and possibly federal law. KnoxKeen, maybe ERISA, state civil code, and HIPAA. If it's employer-based HMO but self-insured, KnoxKeen will generally not apply because of restrictions on KnoxKeen. But the main law that we will look to is federal law, ERISA, and then state laws around HIPAA. To assist you in this determination, I'm on the next slide now. There is a terrific chart on the Health Consumer Alliance website, and I've provided you the web address. And they have a fantastic publication called Summary of Laws Governing Health Plan and Insurers. And it includes a chart not only of the regulatory agencies that provide oversight for private insurance, whether it's managed care or PPO, but also includes a chart on making a determination of which laws apply. And so I've listed just a few examples around HMO and PPO, but there are many other types of examples of private health insurance and types of insurance plan that our clients may have. And because they're more numerous, I chose not to include them in the webinar because of this, because a standalone publication exists. So please use that. And also, I would always, each time you need to make a determination about whether state or federal law apply, and then which state law applies, I would look at this publication every single time, just in case there have been any changes in the law. The staff at Health Consumer Alliance keeps their publications updated, and if you have any questions about whether there have been any changes, you can always call them or call us. A few words about PPOs and which laws apply. So at the very beginning of the webinar, I noted that very generally PPOs oversight is provided by the California Department of Insurance, but there are some caveats to that. So where where the KnoxKeen Act, which I'll talk about shortly, applies to managed care, in some instances it may also apply to PPOs. And the common ones historically have been some of the Blue Cross, Blue Shield PPOs, in which case now KnoxKeen applies, and you're looking at oversight by the California Department of Managed Healthcare. But in most cases, PPOs are regulated by the California Department of Insurance, and you're looking at the state insurance code. So again, another example of it's a moving target, and we have to do an analysis of the characteristics of this particular plan. A few words about KnoxKeen. So the statute is called the KnoxKeen Healthcare Service Plan of 1975, and its purpose is to regulate managed healthcare plans. As mentioned, enforcement is conducted by the California Department of Managed Healthcare, and I see that I didn't capitalize managed. And as I've also mentioned, off the bat, KnoxKeen does not apply to self-insured plans, even if they're managed care plans. And that's because federal law preempts state law from doing so. If it's a self-insured managed care plan, we're looking at federal law, which would be ERISA, and enforcement is provided by the U.S. Department of Labor, Employee Benefits Security Administration. Back to KnoxKeen. Very generally, we will find for statutes and code sections, we are in the California Health and Safety Code, sections 1340 through 1399 et al. There's some sections after the decimal point. And for state regulations, we are in the California Title 28 of the California Code of Regulations, the CCRs. And as always, it's important to look at both state statutes and code sections and the regulations. We must read them both together because the regulations serve to fill in the details of the code sections of the statutes. And also, secondly, we always want to look at both to find out if any changes have been made to either. Again, the Health Consumer Alliance is a fantastic resource. I cannot underscore that enough. And they have a second standalone publication called KnoxKeen Protections, a Quick Reference. And it is very lengthy. The quick reference is probably about 30 pages. But what it provides is a very useful overview of all the sections of the KnoxKeen Act, and even more fabulously, a chart that for each topic and subtopic gives you the code section that applies, and a summary, a brief summary of what it's about. So I highly, highly recommend this as an advocacy tool. And for our purposes, I just wanted to select a few of the topic areas that might be relevant to your work. And these are the topic areas of the KnoxKeen Act itself. Consumer protections, access to care, specific service coverage, continuing coverage, so that's where a person may be employed and then is terminated or leaves their employment, and now we're talking about COBRA coverage for a limited period of time. Also grievances and other dispute resolution, utilization review, and claims processing. There are many, many more, but for our purposes, these seem the most relevant to highlight. But again, I want to refer you to the Health Consumer Alliance publications about KnoxKeen if you've not used them already. Next, California Regulatory Agencies for Insurance and Managed Care Issues. We've we've covered some of this already, but I wanted to provide a little more detail. So as mentioned, we're in the land of HMOs. Oversight is provided by the California Department of Managed Care, and they have an HMO help center that is available 24 hours, 7 days a week, and I've provided you with the phone number and the website. For PPOs, again, that caveat is that some plans may fall under the auspices of DMHC, but where it does not, we're talking about the California Department of Insurance, and they have a consumer hotline, not available 24/7, but is available during the work week, Monday through Friday. And I provided you with the phone number and their website if you don't already have these. And for self-insured plans, because of that exemption, that federal law preempts state law, we're going to look to the U.S. Department of Labor Employee Benefit Security Administration, and they too have hours and a phone number and website, and I've provided you those as resources. Any questions on this section? So again, I know I'm being very, very general, but that's because there is particular and precise analysis to be done with each policy. And my goal here is to situate you, to give you the big picture, to give you some language, to give you tools of what does the lay of the land look like. I don't see any typed questions. Are there any questions for this section? And does anyone need to know how to find the Health and Safety Code or the California Code of Regulations? Okay, I don't see anything. I'll move on. If you think of something, please feel free to ask. Okay, our next section is about the main topic of the day, appeals. I wanted to set you out with information about making requests first and what is the applicable law, because not every case is going to go to appeal, and so I wanted to give you some basics about ingredients that might help avoid having to appeal a decision. Okay, but if all things fail and there's disagreement with the insurance company, what are the rights and remedies available to our clients? The big picture is that there are two ways to appeal. One is through the insurance company's own internal process or through going to court. For the purposes of this webinar, I am not going to speak to litigation. I am going to speak to working directly with the insurance company and with the state agency that has oversight, so Department of Insurance or Department of Managed Care Services. Resources along the way to resolve the matter as informally as possible or more formally through a formal appeal include the ombudsperson for the health plan for the insurance company may be very useful. Also, the HMO Health Plan Help Center, which I'll talk to a little bit later, and then the state agency that provides oversight, whether that's DMHC or Department of Insurance, they have their own complaint process as well. And I'll speak to when is it time, what some ideas around timing of when do you get these folks involved or not. So managed care plan appeals, there's two broad concepts here. One is the plan's internal process, the HMO plan's internal process. And the second piece is there may be instances to go outside the plan, to go to Department of Managed Healthcare Services and ask for an independent medical review. So firstly, working with the HMO, the insurance company itself. So we were looking in the policy language, the evidence of coverage, and any other documents that make up the entire policy for language of what is their internal process. when there's a disagreement. It could be called a grievance, it could be called an appeal, it could be called both. We want to know the timelines, we want to know the process, we want to know who the players are, who's involved, who's responsible for what, and that includes the client's responsibilities. So as always, once we learn the rules, we need to follow that protocol and abide by that process and those timelines set forth. A grievance can be filed in writing or maybe allowed over the phone or online, depending on the resources of that insurance plan. As an advocacy tip, we always recommend putting everything in writing. So an email may be an option, but there may not be proof that the company received that email. But a writing by fax, for example, you get confirmation that at least the fax went through and the date and time. Or if you mail it, there are ways to get proof that it was delivered and received, for example. If it's done by phone, as always, we want to write down who did we talk to, the date and time, what is their job title. So state law provides through the KnoxKeen Act, and this is set out more in that Health Consumer Alliance publication that I mentioned, and also in our chapter about private insurance appeals, that generally the standard review period for a grievance is 30 days to be reviewed and a decision to be issued, and where it's a more urgent matter, 72 hours. The plan issues a decision and will either uphold or overturn the initial underlying decision that is disagreed upon. Let me go back actually for a second. So again, very general here, but it really is plan specific. And we want to know, we want to keep our eye on, are we dealing with the HMO plan itself in that company, or are we dealing with the broader health insurance company? So for example, HealthNet is the insurance company, but Monarch may be the HMO. Who are we dealing with? Whose process are we dealing with? Where are we situated here? Who's who? What's what? What are the timelines? What are the responsibilities? In some cases, it may be possible to get this independent review, a second opinion. And that's called an independent medical review. And this applies to problems around disputes about whether medical necessity exists or is being met by the equipment or the service, reimbursement for emergency services, and issues around whether, in fact, the requested service or device is experimental or investigational. And that's a contentious issue, which can differ from expert to expert, for example. And so what one does is they contact the Department of Insurance or Managed Care and ask for this independent medical review. And then it is reviewed by a team, an analyst, clinical staff. So that's going to be someone we would expect to be more knowledgeable about disability and medical conditions, and also legal counsel. I want to defer to the process of the agencies themselves for the finer details about the process for asking for an IMR. So some recommendations around an approach for advocacy. I'm switching back now to managed health care. Because there's more, and the reason is because there's more infrastructure already in place. The PPOs are a looser possibility, meaning that the infrastructure, you really have to look to the plan itself. There aren't pieces already sort of established. So for managed health care, where there's a dispute, one first step could be talk to the doctor, talk to the health plan, find out what's going on. And where this could be helpful is when a process is purely done through an exchange of paper, information is not always captured. So a denial might come through and say, denied, no medical necessity. Now, using a concept from Medi-Cal, we would expect a little more detail so that the client knows how to respond. Well, what is it about medical necessity that you didn't find? What do you disagree with? And it may not be there in writing. So talking to the health plan to get more details can be very useful. It may be, well, it really is just this minor issue, but we had to deny it because there's still a dispute. But it's really, not a really big deal, and here's what we need to satisfy our question. So it's good to talk to the players involved. You can also file a grievance or complaint with the health plan itself if this very informal way of resolving the matter doesn't work. Another tool is to call the health plan help center. This is the HMO health plan help center that I mentioned earlier, to get a third party involved. And then have a discussion about whether an independent medical review might apply here, whether that process is appropriate. And then filing a complaint. So just some steps in the process from as informal as possible up to far more formal to try to resolve the disagreement, to get more information. And again, the Health Consumer Alliance is a fantastic resource, and they have a 4-page sheet called "What to Do If You Have a Problem with Your Health Plan." They have this for Medi-Cal and also for private insurance. So I defer to their expertise in their publications for advocacy as well. PPOs, again, are a little bit harder to pin down. And so I refer you to the health plan itself. What are the rules that the insurance company has set forth for disagreements and disputes? And so I think it is fair to say that the common thread, whether it's Medi-Cal or private insurance, HMO, or PPO, that some of the key ingredients will be the same. And that is a strong medical necessity justification that's in writing, that all the key pieces of requested information have been provided, are accurate and complete, that the process set forth by the insurance company is followed, and that one knows what the big picture is and the steps in the process. The interesting thing about private insurance, especially where it's an employer-provided policy, is this notion of kind of like the bargain of the discussion about the terms. Where an employer provides health insurance, the employee may have nothing to do with the discussion of the terms of the health policy. It's something that the employer has negotiated. They've negotiated the price, the terms. In some cases, the employer may get quotes for a few different types of plans, a few HMOs, a few PPOs, and a few specific plans for each, and bring that to discussion with the employees so that they can choose or vote as a group which plan would suit their needs or most of the group's needs. But just this notion that the insurance company typically does not conduct a negotiation with the insured. And so where there's an issue of interpretation of the terms, generally courts will side with the insured because there wasn't this kind of level playing field discussion. But again, I for our purposes, I'm not going to talk about litigation, but just a concept to know. Again, for PPOs, once you've had all the documents in hand that comprise that policy, the go-to people, again, would be the State Department, California Department of Insurance, or in limited situations, the California Department of Managed Care. And these are, again, you want to look for an ombudsperson. You want to look maybe for a caseworker as well, someone who can help, and maybe more ombudsperson or caseworker in the preparatory phase, where you've not requested the equipment yet, or there are some questions that the company has about this piece of equipment. Someone who can help the client navigate that system, navigate the HMO, navigate the PPO plan, who may be able to get more responsive and timely answers to questions. This is especially useful where our clients have complex disability and numerous medical needs. Someone who can just help us find the way. That doesn't mean an assurance that all will go well or smoothly, but someone who knows the system at hand and can help us move through it. Lastly, and I see a couple questions have come in, these are the resources that I previously mentioned. So there's us and our staff in our regional offices and Office of Clients' Rights Advocacy. Also, I wanted to underline and underscore the National Assistive Technology Project. The director there is Jim Sheldon. Another attorney there is Diana Straube. They do specific advocacy in New York, but they keep an eye on national issues, and also know of private attorneys and nonprofit attorneys that specialize in specific areas around assistive technology, whether that's national issues with regards to speech-generating devices or AAC devices, or wheelchairs or private insurance. They're a fantastic resource. And the website is the www.nls.org. That's for the whole organization, but on their main website is a link that says National Assistive Technology Project, and there you can find they issue throughout the year newsletters that will pick a particular topic and then talk in great detail about them. It might be employment and SSI and assistive technology. It might be nursing homes and assistive technology and Medicaid. Just to illustrate a few, it might be special education and assistive technology. So it's a fantastic resource. For insurance and healthcare needs, the Health Consumer Alliance and the National Health Law Program are the go-to resources. The Health Consumer Alliance has been a project and has been funded through NHELP, the National Health Law Program, and so I would call them and go to those websites where the issue is not so specific, it's not for expertise in assistive technology per se, but it is for expertise around Medicaid and also private health insurance, as well as healthcare reform and the changes that are pending and the ones that have already taken place. I see a few questions have come in. Let me review those and do my best to address them. From Sandra, I have a question referring to helping to advocate for DME coverage for plans such as Kaiser. Yes, whose patients live outside their coverage area. I have consumers up in the mother lode who have Kaiser, but there is no HMO up there. Some have been denied DME, like wheelchairs, only because of their zip code. Can you address these types of situations and give suggestions on how to help advocate for those falling into this category? As a start, I am aware of issues with Kaiser. and DME, and actually have a question for everyone on this webinar if they would contact me offline about Kaiser and DME and coverage. And I will provide my, you have my phone number, and I forgot to include my email. I apologize, and I'll provide that at the end. The question about outside the coverage area, I am not as familiar with. I apologize, but can offline direct you to someone who is more knowledgeable. I believe, is the mother lode up in sort of the Sacramento area? The reason I ask is I would refer you to our regional office that has the catchment of that area, and also I can try to provide some assistance offline as well with determining who that person is, and also addressing this larger question about being outside of a coverage area. And once we determine an answer, I can share that with CFILC for distribution so that all can benefit from that, if that's okay. From Kim, the second question: I've helped consumers and family members through the IMR. It's all about documentation and understanding your medical necessity. We have received favorable decisions more often than not. Terrific. So I guess my question to you, Kim, then is the recommendations around effective and strong medical necessity consistent with your experiences with what led to a favorable outcome? Next question, can I ask a question for a consumer under TRICARE? You may, but it's outside my expertise. So TRICARE Prime, I do not have expertise with that. So I'm going to have to probably offline talk to you about the specifics to try to direct you to whether that would be someone within our agency or outside our agency, and I apologize for my limited knowledge there. From Sandra, okay, Amador, Calaveras, Tuolumne, and Mariposa, that might be our Fresno office. Okay, thank you. You'll contact me via email. Terrific. Okay, then the question about TRICARE Prime. Okay, so I'll talk to, looks like I'm talking to Sandra and Jorge offline. Is there any, I think those were the two that I needed to provide some follow-up with. So for everyone else, you have my phone number. It's 213-213-8000, and for anyone who has attended a previous webinar that I've conducted, that is a new phone number. Our Los Angeles regional office moved in April. My email, however, has stayed the same. I think if I just type it into the dialog box, and I also will say it aloud, if that's all right. So I'm providing my email address in the dialog box. Just sent it through, and it's also, it is HILLARY.SKLAR@disabilityrightsca.org. So that the last part's the same as our website. And for more specific questions or the questions that I could not answer during the webinar, please feel free to contact me. And if I'm not the person, or if your client is not in my catchment, I will work on identifying someone to assist you who may be more appropriate. Any other questions? I know this is a very broad overview, but again, my goal was to provide you with tools for the lay of the land. And again, I cannot underscore enough the importance of medical necessity and proper, accurate, strong documentation. In many cases, it can avoid disputes or lead to a positive resolution. I don't see any other questions. Thank you all. I'm going to turn this over to Rosemary again. Again, please feel free to ask me questions, and where topic area, I believe one or two of them were fairly broad, where I'm able to find a resource or more specific information, I'll share that with Kim Cantrell to distribute to the group. Thank you.